And the first matter before the court is Kennebec 23-280, Chris Calnan versus Sam Hurley et al. I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web, both by video and audio. I would ask before we begin to have counsel introduce themselves by saying their names for the record, starting with the attorney for the appellant.
Good morning, Your Honors. Terry Mitrenga, representing appellants Chris Calnan et al.
Good morning, Sarah Coleman for the Appellee to the Attorney General's Office.
Thank you. And counsel, if you're ready to proceed, I'd be happy to hear your arguments.
Thank you. Thank you, Madam Chief Justice and Associate Justices. May it please the Court. The issue in this case is the validity of the immunization rule promulgated by Maine EMS. A fundamental requirement of agency rulemaking is express delegation. In this case, there was no express delegation. The trial court acknowledged this fact, stating, the legislature need not explicitly grant the board the power to adopt immunization requirements as it did with the HHS. Instead, the court found that the agency's rulemaking powers stemmed from reasonable inference based on isolated phrases pulled from a single provision. The legislature enacted the EMS Act in 1982. At the time, there weren't any immunization rules or vaccine mandates in place for any healthcare workers. 7 years later, in 1989, the legislature enacted the legislation titled Control of Notifiable Diseases and Conditions. Under this separate act, healthcare workers employed by designated healthcare facilities were subject to vaccine mandates, and healthcare workers not employed by designated healthcare facilities were excluded from the mandates. EMS workers remained members of the excluded class for the following 35 years, until MEMS independently promulgated its immunization rule. In the Kimball case, the law court stated the following: if the meaning of this language is plain, we must interpret the statute to mean exactly what it says. Stated succinctly, when the language chosen by the legislature is clear and without ambiguity, it is not the role of the court to look behind those clear words in order to ascertain what the court may conclude was the legislature's intent. The plain meaning of the EMS Act is clear. The stated purpose is to promote and provide for a comprehensive and effective emergency medical services system. I welcome your questions.
Counsel, you started off by talking about how there has to be an express delegation of rulemaking authority. What do you make of 84(1)A? I mean, it says the board shall adopt rules appropriate to carry out the purposes, requirements, and goals of this chapter. Is that not an express delegation of rulemaking authority?
It is, Your Honor, and the purposes, goals, and requirements of the Act are to provide emergency medical services. There is nothing in the Act under any purposes, requirements, or goals stating that the agency is to control notifiable diseases, promulgate immunization rules, or issue vaccine mandates. In fact, the legislature specifically delegated that authority to a separate agency under a separate act.
Counsel, one of the goals, though, is to ensure optimum patient care.
Yes, Your Honor.
Is that not broad enough to permit this sort of a rule?
I would say not, because the purpose is to ensure optimum patient care, and the full sentence says, by providing emergency medical services. It does not say ensure optimum patient care by engaging in conduct to control notifiable diseases.
Could the board have promulgated a rule which said, if you have COVID or have been exposed to COVID and are unvaccinated, you must stay out of work for 5 days?
I don't know if the board does have these emergency powers. As a matter of fact, I don't know if the board has any emergency powers.
I don't think he phrased that as an emergency power, just a power in general. If you have a communicable disease, does the board have the power to enact a rule that says that you must stay out of work? I guess
I would ask if any board of any agency can do that then. If you open the door for EMS to do that, Could any agency do that? Could the Board of
The
Acupuncture
board here
require
is-
their licensees?
The board here transports sick or injured people. And taking language from our case law regarding the safe handling and transportation of patients. If a person is suffering from or has been exposed to the vicious disease that was COVID-19 when it first appeared, how can you suggest that a rule that requires safe handling and transportation of sick and injured people is not within the agency's power?
Because the rule to transfer patients, safely transfer patients, is in the context of providing emergency medical services. It is not in the context of anything other than
So it
that.
just refers to driving the ambulance.
No, I mean, these emergency medical workers,
They're
for 18
providing
months.
patient care, aren't they?
Excuse me, Your Honor?
They're providing patient care, aren't they?
They are providing patient care. And I would also like to point out that when this rule was acted under DHHS, there were several healthcare workers that were excluded from the mandates. Only healthcare workers within designated healthcare facilities were subject to the mandates. And I'd also like to point out that the legislature itself created these exclusions. So MEMS is overriding the exclusions for the regular
So
vaccines.
is MES overruling statutory or legislative guidance? Because doesn't Title 32, Section 81A, basically says the legislature's intent is to designate a central agency to be responsible for the coordination, integration of all state activities concerning emergency medical services.
Okay, then I
So
think that
there
we-
isn't that a mandate for them to go out and to address whatever
Okay,
it takes to conduct those services
So
within the
then
state
we're
of Maine?
looking at the subject matter of the agency. The subject matter of this agency is to provide emergency medical services. If I could go over the definition of what emergency medical treatment is defined as, which I do have here, but there is a separate agency that has been designated the authority to control notifiable diseases. For the entire 140...
And that agency is DHHS, is what you're saying?
Yes.
And didn't DHHS punt with respect to both dental services providers and emergency medical service
I
providers?
don't think DHHS has the authority to punt to other agencies. It is the control of the legislature itself that decides which agencies engage in which conduct.
And it was this agency that was specifically delegated the authority to oversee emergency medical services and how they are provided in the interest of patient care.
DHHS itself did not have the, if DHHS even would have decided to do COVID mandates onto the EMS workers, DHHS's actions
Let me ask you this then.
would have
So-
contradicted the legislature's own intent, which was to exclude certain healthcare workers from the mandates when it created the act in 1989.
Counsel, is your argument, you keep referring to COVID-19, but is your argument limited to the issue of whether or not they could mandate a COVID-19 vaccination, or is it really more broadly that the board has no power to require any kinds of vaccinations? And I know that it's the COVID-19, but also flu that's at issue here. And, you know, there are many other things that might pose a risk, whether it's hepatitis strains, et cetera. Is it your position that this board has no power to mandate any vaccines?
It is my position that any board within the state has no power to issue any immunization vaccines until the legislature expressly gives them that power. The legislature for the last 140 years has been the only government agency to decide when powers are given and to which powers on this issue.
How about masking? Do they have a power to regulate to make them wear masks?
I don't think anybody would dispute that power, but I would say that that's a nominal thing to require somebody versus getting a vaccine.
Well,
Is the
does that
tipping
make this-
point here that a vaccine is intrusive?
Yes,
as
it
opposed to
is.
the fact that a mask is
It's a
innocuous?
constitutional issue of bodily integrity, which has been carefully balanced by even the Supreme Court itself.
So to the extent that the rule, because the rule's been changed, and so identifying what you're challenging as to the rule as it now applies, are you challenging that part that requires masking and only challenging the immunization part, or are you challenging the new rule as a whole and the old rule as a whole, whether they have exceptions for masking or not?
I'm not challenging the masking requirement, but I am challenging the fact that I'd say that was a minor thing. I am challenging immunization rules because the legislature has dealt with this separately throughout the entire 140 years that the legislature has been dealing with contagious diseases. It has specifically assigned delegation to a single agency throughout that 140-year time period, starting in 1885 when the legislature created local boards of health directors, all the way up until now.
On a side issue, is this rule a routine technical rule?
I would say that this rule is that the provision they used isn't even a rulemaking provision that would probably have not received a category designation even if it had been amended.
So you don't even reach that issue. You say that coming through the door, it was invalid.
I addressed that issue in a lengthy amount in my brief, which I'm sure that you've all read.
And we have.
And the reason I say that is because, well, first of all, if we look at the appellees point to the intent of the legislature at the time the EMS Act was enacted in 1982 and say everything was routine technical. Well,
Right.
in 1982, there were no healthcare workers subject to any vaccines or any mandates. So if we're going to go back to 1982,
Well, but that's an important point, is that when do you agree, aside from whether it's within the scope of this agency's authority?
Right.
Do you agree that the rulemaking process, when this statute was enacted, amounts to what we now call a routine technical rulemaking process?
no, I do not agree.
Well, they didn't have
I
major
could explain
substantive
further, but I
rules.
have the yellow light.
They didn't have major substantive rules in 1980. There was no delineation
Yes.
for that.
I do have a point to that. I think
It's
I
not
have
read. You get to
Okay.
keep going until it's read.
All right, so when you look at the authorizing provision the agency used was the main powers and duties, the powers and duties of the board, which they're saying is a rulemaking provision. They say it would have received a category designation if it had been amended after 1996. Yet there are several powers and duties provisions under the same title for professions and occupations for the Board of Podiatry, the Board of Chiropractors, the Board of Acupuncturists, different agencies that have in fact had these powers and duties provisions enacted after 1996, as late as 2007 and 2013. Now, none of those powers and duties provisions received category designations because they're general enabling provisions rather than actual rulemaking provisions.
Thank you, counsel.
Thank you.
Attorney Coleman?
Thank you, and may it please the court. My name is Sarah Coleman. I'm an Assistant Attorney General representing the Appellees. This court should affirm the Superior Court's dismissal for at least 3 reasons. First, the board acted well within its rulemaking authority when it promulgated the rule. Section 84(1)A vests the board with authority to promulgate rules that are appropriate to carry out the purposes and goals of the EMS Act. And the rule does just that. By minimizing the risk that patients contract deadly diseases while in EMS care, the rule advances at least 3 of the key purposes specifically enumerated in the Act, such as ensuring optimum patient care, ensuring the safe handling of patients, and ensuring patients receive treatment consistent with appropriate medical guidance. Second, the board properly treated the rule as routine technical. At the time Section 84 was enacted in 1982, there was no such thing as major substantive rules. All rules at that time were by definition routine technical. 14 years later, in 1996, the legislature first created the rule categorization scheme, but it only applied to rulemaking delegations enacted after 1996. And because Section 84 predates this creation of the major substantive category, rules promulgated under this provision are necessarily routine technical unless and until the legislature adds a major substantive designation. Third, the lower court did not err in declining to supplant the board's judgment with that of appellants. In promulgating the rule, the board weighed the allegedly competing interests of the value of a vaccination requirement against the potential risk of worker shortages. Appellants now ask this court to second-guess that judgment. But this court has held that a party's disagreement with policy is not enough to invalidate a rule. The legislature vested the board, not the appellants and not the courts, with the authority to carry out the purposes of the EMS Act. For these reasons, this court should affirm the Superior Court's dismissal of the complaint. Thank you, and I welcome your questions.
Let me ask you this, under going to the categorization of the rules as either routine technical or major substantive, I understand your argument that that statute doesn't apply to the rulemaking authority of the board here. Putting that piece aside, if it did apply, would you agree this would be appropriately characterized as major substantive rather than routine technical?
I would agree if there was a specific designation in the statute that this is that this type of rule is major substantive. I think there has to be an express designation of major substantive.
By looking at the definition of major substantive rule, I understand it's not designated as such. Would you agree that this is essentially fits that categorization?
Your Honor, I don't think it is up for us or any party to decide. I think sometimes the legislature makes things that may look major substantive, they designate it as routine technical. And so I really think that that question would be a question for the legislature and only the legislature to decide.
As we look at the purposes set out under 81A, it lists quite a number of different things there, and we read through them. Planning, evaluation, coordination, facilitation, regulation, well-coordinated trauma system, safe handling, transportation, centralized dispatch, things like that. All seems to deal with how the system works. In other words, how you don't want people running out there in a station wagon throwing people in the back of the car. The state wanted a very organized system of picking up people who need help, transporting them safely. Do you agree that there's a big difference between just running an organization that has good drivers and good vehicles and good equipment, as opposed to injecting a foreign substance into a person's body that is intended to be absorbed and change that person's immune system? Do you agree that's a big deal?
So Your Honor, I would agree that the transportation piece is different than the actual provision of healthcare. But I would disagree that Section 81A is limited to just transportation. There are specific aspects of this provision that relate specifically to medical care, such as the treatment of patients under the appropriate medical guidance, the safe handling of patients. And I believe Justice Douglas earlier mentioned, like you've got individuals coming in here who have an emergency. We've got some of the most vulnerable people in the healthcare system. We've got people having heart attacks, strokes, a cancer patient coming in, and the last thing that they need while in EMS care is to be exposed to a potentially deadly disease. And there is a reason that we have...
That's all understood. I mean, they need to wear the gloves, they need to wear the masks and all that stuff to avoid the infection. But I guess my question to you is immunization, injection of a foreign substance, in a whole different category than what 81A is telling us to do, the bullet point list of what it's telling. Do you agree that it's a different animal?
No, Your Honor, and I will note that the rule as amended has an option for individuals who do not want to be immunized to wear a mask.
So wouldn't it make more sense to have DHHS be in charge of this across the board for EMTs and as well as other medical professionals?
Your Honor, that may well be so, but that's not how the legislature has handled this. And I note that DHHS, the statute that they are enacting, I'm not sure that they have the authority to regulate the EMS workers, because EMS, the Maine Emergency Medical Services, has that authority. And so for whatever reason, this is how the different industries are being regulated.
Now, the EMS rule basically is tagging along with whatever DHHS says, correct, so far?
I guess, yes, so far, I guess we can say that is fair, and that is, I think, evidence that the board is taking their obligation seriously. They are, experts in the industry. They're doctors, nurses, people who run hospitals, but they also look at everything available to them. And so CDC guidance, both national, federal, as well as state, are instructive to them.
So the members of this board have the expertise to make these medical decisions?
Absolutely, absolutely.
To the extent that one accepts that the immunization rules are consistent with being technical rules, was there ever anything pointed out in this record that suggested that the board failed to follow the appropriate rules for rulemaking?
Other than the allegation of that it should be routine technical rather than major substantive?
Right.
No, Your Honor, there's no other procedural challenge. And I would like to take this opportunity to clarify two pieces in Appellant's reply brief relating to this issue. Specifically, and I just heard my colleague say this, the rules are, the statutes that are cited regarding, the Board of Podiatry, the Board of Medical Practice, all of those enabling statutes were in the same boat as Maine EMS. They were actually originally enacted, we looked at the archives, long before the 1996 requirement, in the 50s, in the 70s, in the late 80s. So I think that's just a misstatement of fact. Those provisions are actually were enacted way before and are in the same boat as Maine EMS regarding whether or not they can be routine technical or major substantive.
Well, it's my understanding now that it's the plaintiff's position that they aren't challenging a masking rule. So the rule that is effective now
Yes, Your Honor.
gives that an option to be masked instead of vaccine. So is this case moot?
So this is the first time that I am hearing that the masking requirement would, from them, they would agree that that's not something they are challenging. If that's the case, yes, I would suggest it's moot. We have taken the position that our understanding is that they are still challenging the influenza requirement as it was stated in the amended rule, and because of that, we believe there's still a live controversy.
But under the rule that's in effect now, you don't have to be vaccinated for the flu if you mask. So it sounds moot to me.
Your Honor, if that is the position appellants are taking, then we would agree that it is moot, if they are no longer challenging it because of the masking requirement.
Well, were they just challenging, this may be a better question for opposing counsel, but were they just challenging the immunization with respect to COVID-19 and influenza, or were they challenging the entire scheme of any type of immunization?
So that was the scheme, was COVID and influenza. And now my understanding, because COVID has been removed and several other diseases actually have been added in to be consistent with the DHHS rule. And so my understanding is that the only live controversy at this point is just related to influenza. But I think you would have to ask appellants.
When I
what they
asked, she
challenge.
said that they were challenging any requirement to immunize. I understand that the rule that was specifically challenged only dealt with COVID-19 and influenza, but it's my understanding that subsequent enacted rules may remove COVID-19 but add other things.
Yes, Your Honor.
Okay.
But does the now in effect rule allow for masking as an alternative to any vaccine?
I believe so, Your Honor.
Record, can you point?
Yes. So I think it's just as to influenza.
Okay, so if they're still objecting to being vaccinated for German measles or something else, then a mask would not be an alternative, and so that aspect would not be moot.
I think that would be correct, Your Honor. Your Honor, I would also take this opportunity to add that also in the reply brief, there was a reference that Section 84, this is the first time that Section 84 has been used to promulgate rules, and that is factually incorrect. There are at least 8 rules on the books right now that cite Section 84, and I looked at, we were able to identify at least in the late two that I don't believe are on the books now, have since been amended, that were adopted in the late 80s. And so I think that's just helpful for your honors.
Thank you. There don't appear to be additional questions, so unless you have something else you wish to add?
Your honors, thank you very much.
Thank you. And Attorney Mitrenga, you reserve 3 minutes.
Just a few brief points. I do want to make clear that the challenge here is that rulemaking was engaged in without express delegation from the legislature. And that is prohibited for any kind of rulemaking, whether immunization or anything else.
Okay, but so I challenged you already on that. There is an express delegation of rulemaking authority. What you're really saying is it has to be more specific as to what they can make rules about?
I'm saying that the plain meaning and the plain language of this statute does not contain anything to do with controlling contagious diseases, immunization rules, or vaccine mandates. There's not a single word without the entire.
I understand. And so what you're really arguing is that it either contravenes the purpose of the act or exceeds their rulemaking authority, but they have you agree that under Section 84,
They have
rulemaking
rulemaking authority for emergency medical service provision, not immunization requirements, controlling contagious diseases. And
Does that mean that the board cannot enact rules requiring EMS workers to wear gloves when handling patients or not show up to work when actively showing symptoms of an illness?
This is not a challenge in this case. The only challenge in this case is for the immunization rules. So hypothetically, I haven't thought of those issues. I don't really have an answer for those issues.
But don't they fall under the same rubric that there isn't an express delegation of authority to make up rules with respect to wearing gloves or?
I don't think so. As Justice Meade said, this is a different animal. This involves bodily integrity and injecting somebody with something. And it is a requirement that affects these AMS workers' jobs. And I want to make clear that none of us, if you start giving boards these specific powers instead of going through the legislature was not involved in this at all. The legislature did not expressly delegate the powers to this agency to engage in this specific conduct. Appellees say, well, we are in charge of all EMS workers. I mean, that is such a broad statement. Does that mean that they can take over the motor vehicles and start designing the licensing requirements from the ambulance drivers? They are literally taking legislative powers given to another agency.
But doesn't the process allow for input from the public in terms of the rulemaking itself and to have these types of issues that are then discussed and addressed in the context of the rulemaking process?
It should go through the legislature. The legislature is the only entity that has the power to decide and has been the only government authority who has decided these matters for the last 140 years.
Does that mean that if DHHS had enacted a major substantive rule requiring EMS workers to be immunized against COVID, you would not be challenging that rule?
I think then that it would be a different issue, because when the DHHS was given this authority in 1989 under the Control of Notifiable Diseases and Conditions Act, DHHS, they were subject to other statutes put in place by the legislature. The legislature designated only certain healthcare workers were subject to the vaccine mandates, and several weren't. Non-designated medical facilities were not subject to. So there's basically thousands of healthcare workers who currently are not subject to vaccine mandates per the intent of the legislature.
Your time is up.
Thank you.
It actually has been up. You were allowed to answer the question, so.
Yes.
All right, thank you, counsel. As is our usual practice, we will take this matter under advisement and issue a written decision in due course. I also understand that it is your first appearance in front of this court for both attorneys Coleman and attorney Mitrenga, and so therefore we would extend an invitation to take the greetings of the court, as is our usual practice in chambers.